I'm Dave Mullins. I'm a podiatric surgeon and healthcare attorney in Northern California. I'm also the author of the book, How to Win Medicare Appeals, published by the American Bar Association. This podcast is based on that book, and this is episode number 3 of the podcast. Let's get started. If ALJ appeals are as easy as I say they are, why do attorneys lose ALJ decisions? I think they lose because they fail to answer the 5 questions. We're going to get back to those 5 questions in just 1 minute. Or they fail to provide understandable answers to the 5 questions. Or the appeal was doomed right from the beginning because the ALJ had no discretion in the matter. Or Medicare was right and the provider was wrong. Before we go to the next slide, let's try and answer the question. What are the 5 questions? 1. Please do it with me. We're going to be doing this over and over again. Hopefully you're going to be bored with this exercise within another episode or 2 because you'll have these down. But you need to understand that these are the 5 questions that you have to answer every time for the ALJ. 1. What was wrong with the patient? 2. Why did that problem require treatment? 3. Exactly what treatment was provided and why was that the best choice for that patient at that time? 4. How do you know that was the best choice? Meaning what authorities support what was done? And 5. How were Medicare's denial reasons wrongly applied, or more commonly, why should the Medicare payment policy that applies to your denied claim not be applied? Let me give you an example of an appeal where the ALJ has no discretion in the matter. Let's say a patient is admitted as an inpatient to an acute care hospital for a semi-elective hip joint replacement procedure. And on the second post-op day, the surgery's gone fine. On the second post-op day, someone comes around from the hospital and tells that patient that their hospital status has been changed from inpatient to outpatient. Can that patient appeal that change in hospital status? Well, under 42 CFR section 405.926U, a hospital's designation of outpatient status is not appealable. This decision has already undergone some change as a result of the January 2022 decision by the Second Circuit Court of Appeals in the case of Alexander versus Azar. But for now, let's assume that CMS Medicare is going to continue with this case right up to the Supreme Court, and therefore that this 42 CFR section still applies. How did the change from inpatient to outpatient status affect that Medicare patient? Well, with continued inpatient status, Medicare would pay 100% of the patient's hospital bill under Part A and 100% of the SNF bill under Part A. But with the change to outpatient status, Medicare is going to pay 80% of the hospital bill under Part B, and Medicare is not going to pay a penny of the skilled nursing facility bill. Who are the hip surgery patients who only have Part A? They're the Medicare patients who can't afford to pay the Part B premiums. Some of you watching probably don't realize that everybody has Part A Medicare as long as you've been paying those deductions from your paycheck to Medicare for 10 years, or in other words, for 40 calendar quarters. Once you've made all of those payments, you have Medicare Part A from age 65 on for the rest of your life, and you don't have to pay another penny for coverage under Part A. Part B is completely elective, and you have to be able to afford to pay those Part B premiums out of your own pocket. At any rate, we're going to return to this problem in episode 8 or 9, but you'll see in just a minute why I've put this problem in at this point in the podcast. How many levels are there to Medicare appeals? There are 5 levels of appeal after the initial claim is denied. The first level appeal is the redetermination appeal. The second is the reconsideration appeal. The third is the ALJ appeal. The fourth is the Medicare Appeals Council appeal. And the fifth is the appeal done in federal district court. Are all 5 levels of appeal created equal? Yeah, absolutely not. Why is the ALJ appeal at the 3rd level of appeal the only level of appeal that actually matters? Because you're not going to win before or after the 3rd level administrative law judge appeal. There's only one sweet spot in the entire Medicare appeals process, and that's with the ALJ. If the 1st and 2nd levels of appeal are only going to result in denials, why not go right away to an ALJ appeal? You can't. The Administrative Procedures Act is a federal body of law that controls all of Medicare, and the exhaustion of remedies doctrine contained within the Administrative Procedures Act requires the exact correct order of appeal every time. You have to successfully complete the 1st level redetermination appeal before you qualify to request the 2nd level reconsideration appeal. And you have to successfully complete the 2nd level reconsideration appeal before you qualify to request the 3rd level administrative law judge appeal. How did we get to the current adversarial point that we're at with Medicare? And now I'm talking about that situation of inpatient to outpatient status. In 1966, when Medicare started, there were only 19 million beneficiaries and life expectancy was only 70. By 2015, we had 55.5 million Medicare beneficiaries, and life expectancy had increased to 78.8 years. Now, we have more than 3 times as many Medicare beneficiaries as we had when Medicare started. Average life expectancy has increased by almost a decade, and the average annual cost of care for the average beneficiary has gone through the roof due to things like MRI studies and CT scans and artificial joints and the pulse oximeter that allows 80-year-olds to safely undergo general anesthesia. How has Congress responded to these changes? And this gets back to that slide of inpatient versus outpatient status. Congress has unfortunately responded by decreasing benefits for the patients, by tightening the payment rules for the providers, and by decreasing payments for the providers. Why has this created a unique opportunity for coders, billers, legal nurse consultants, and attorneys? The Medicare administrative law judges are still independent, and they will decide in your favor if your answers to the 5 questions, we're going to get to them below, if your answers to the 5 questions are objectively correct, based on the evidence you submit to the qualified independent contractor for the 2nd level reconsideration appeal, and if your arguments are persuasive, meaning your arguments in favor of payment make more sense to the ALJ than Medicare's arguments against payment. What are the 5 questions? 1. What was wrong with the patient? 2. Why did that problem require treatment? 3. Exactly what treatment was provided and why was that the best choice for that patient at that time? 4. How do you know that was the best choice? Meaning what authorities support what was done? And 5. How were Medicare's denial reasons wrongly applied, or why should the Medicare payment policy that applies to your denied claim not be applied? That's it for today's episode. I'll see you in a week.